I'm Jonathan Wilson. I am one of the co-founders and the CEO of the FinCEN Report Company, and welcome to the FinCEN Report podcast. If you're one of our listeners, you know that we are an online service provider. We help small businesses file their beneficial ownership reports with FinCEN under the new Corporate Transparency Act. And we use this podcast as a platform to highlight issues and to bring out speakers and thought leaders that are of interest to the law firms who use our software and small businesses who use our filing services. Today, we're going to be talking to Jim Richards. And Jim is a well-known spokesperson in this area. He's written books on anti-money laundering compliance, and he most recently testified before a committee in the House of Representatives about FinCEN's delays in implementing their regulations under the Corporate Transparency Act. He has some really strong opinions, but they are really interesting and especially educational for everyone out there who is getting to know what the Corporate Transparency Act is all about. So sit back and enjoy our conversation with Jim Richards. So Jim, thank you so much for joining us today. Why don't you tell us a little bit about yourself and your practice?
Sure, Jonathan. Thanks for having me. So, I won't go, I was born in such and such. But I did start out as a barrister in Canada doing commercial litigation. After moving to the US, I followed my wife, who was an OBGYN, into Boston. I eventually ended up as a prosecutor doing organized crime, narcotics, asset forfeiture type work. And it was because of that and my business degree that I had that they had me do all these economic crime cases. And I got involved in some money laundering cases, which resulted in, I published a textbook on transnational crime and money laundering back in 1998. And by the way, it sold more copies in Russian the first couple of years than it did in English, which is a little scary.
Perhaps they were thinking of it as a how-to guide. I don't know.
Yeah. And then I ended up as a BSA officer at Bank Boston in the late 1990s. And I did that at Bank Boston, which became part of Bank of America. I left there and went to Wells Fargo in 2005. I was the head of financial crime at Wells Fargo for 13 long, tortuous years until retiring in 2018. And then I've had my own consulting business since 2018.
Gotcha. So our focus here at FinCEN Report, of course, is on the Corporate Transparency Act. And before we get into all the details, why don't you just give our listeners, your perspective, your overview of the CTA?
Sure. So the Corporate Transparency Act, it was part of the Anti-Money Laundering Act of 2020, which in turn was part of the National Defense Authorization Act for fiscal year 2021. But the CTA, as it's known, is intended to address the problem of lack of transparency into the ultimate beneficial owners of legal entities, and then how bad actors, criminals, corrupt politicians, Russian oligarchs, etc., hide their beneficial ownership of those entities to facilitate their criminal activity and launder and hide proceeds of their activity. So the CTA attempts to accomplish that in two ways. First, by requiring some legal entities to submit a report that sets out the names and identifying information of their beneficial owners. So that's known as the reporting requirement. And then second, by allowing certain public sector agencies and some private sector financial institutions to access that beneficial ownership. So that's really the gist of it.
Sure. And so from your perspective, was CTA's passage a good thing? What did you think when the CTA was first passed?
Well, my first thought was sort of finally, because, it was an awful long time coming. Arguably you can go back more than 25 years for when this beneficial ownership issue first came up.
Right. And just for our listeners, what was the milestone 25 years ago?
Well, there's an organization called the Financial Action Task Force, or FATF, or the FATF, as it's known. And that was created in 1989. It was part of the Group of Seven, or OECD countries, as a way for those countries to address the problem of money laundering. So the FATF started off with developing these recommendations for their member countries, and it became the 40 recommendations. And the member countries were to adopt those recommendations. And that was sort of a technical compliance issue. Then a few years later, the FATF said, okay, well, how effective is this stuff? So they came up with what they called immediate outcomes. There's 11 of them. So then they decided, okay, fine, let's each evaluate each other to see how well the countries are doing on these recommendations and immediate outcomes. And then actually score the countries on these evaluations as to their technical compliance with the recommendations and their effectiveness against the immediate outcomes.
Right. And so how did the FATF evaluate the United States?
So the U.S. was first evaluated in 1996. And the FATF found that the U.S. was non-compliant, the lowest grade, with a recommendation relating to transparency and beneficial ownership of legal persons, is the term that the FATF uses. Those evaluations are done on a 10-year cycle. They're going to move to a 5-year cycle, but they had been done on a 10-year cycle. So the U.S. was reevaluated or evaluated in 2006, found non-compliant, again, for that same transparency and beneficial ownership recommendation. Then they were evaluated for a third time in 2016, and again, non-compliant. So it's been a real embarrassment and a long, long embarrassment in the U.S.
Sure. Now, a lot of us who advise small business clients are familiar with the process of business customers of banks having to fill out, KYC forms every time you open a new bank account. Doesn't that sort of beneficial ownership regime, help a little bit as it relates to money laundering?
Well, it certainly does. So that regime that you're talking about was the U.S. published a rule, FinCEN, Financial Crimes Enforcement Network, part of Treasury, published a rule in 2016. And that rule required banks to collect and somewhat verify beneficial ownership information. And again, that was customers at account opening, like you mentioned. So that rule sort of coincidentally sort of happened around the same time as that 2016 evaluation. But the 2016 evaluation the result was still non-compliant. So the rule that was published in 2016 was first proposed in 2012. And the implementation date wasn't until May of 2018. So the rule to collect that beneficial ownership information didn't impact the rating. The U.S. was still non-compliant.
It was too late.
And it was actually in a sort of a follow-up exam in 2020, they were still found to be non-compliant.
So after passing that rule in 2016, couldn't we have given that more time to take effect? I mean, why did Congress feel compelled to act in 2020, only 4 years after FinCEN adopted the rule in 2016?
Well, that's a great question, actually. So the FATF recommendation refers to a national or centralized database of beneficial ownership information that can be accessed by what they call competent authorities. So that's the recommendation. The 2016 FinCEN rule didn't include a national database. That's what the CTA calls for. It's a centralized database to be built and run by FinCEN, where reporting companies will report their beneficial ownership, and authorized public and private sector entities, think of law enforcement agencies, can access that information. And this beneficial ownership law is intended to replace the 2016 beneficial ownership rule. But here's an interesting aspect of the CTA. I've read pretty much everything there is in the congressional record about the CTA. And I read back more than a year before the CTA was made into law on January 1st of 2021. And there is nothing in the congressional record that I've seen to suggest that Congress even considered that 2016 beneficial ownership rule. So we were sitting on, at the time, to your point, 2+ years of data on a collection and possible use of beneficial ownership information, yet nobody thought to look at it to see if collecting that information actually reduced financial crime. It was a huge oversight in my opinion.
Sure. So FinCEN imposed this duty on the banks to collect the data. We hadn't really had that much experience to determine if it was working or not. And then Congress went and adopted the CTA as a statute to require a national database like FATF was recommending, without really looking back to see what the experience had been under FinCEN's 2016 rule. Okay.
Absolutely. Absolutely.
All right. So Congress basically passed this law to adopt a national database of beneficial ownership like FATF was recommending, even though FinCEN had the banks collecting beneficial ownership information. And Congress didn't really take into account whether that was working and how well it was working. So if you had been a legislator, how would you have made the CTA different, as a matter of statute?
Well, I mentioned the National Defense Authorization Act earlier. NDAA is what it's called. And that act does what its name suggests it does, authorizes funding for national defense. NDAAs have been passed every year for 60 or so years, and each annual NDAA is as sure a thing as there is in Congress. So congressmen try to attach their pet projects or pet bills to the NDAAs, hoping they get passed along with everything else. So that's what happened with the AML Act and one of its main provisions, right, the CTA. Various versions of a corporate transparency or beneficial ownership bill have been introduced in every Congress going back at least since 2008. But none were passed. Carolyn Maloney in New York, she introduced 7 or 8 every year for 8 years. Carl Levin, when he was a senator on Michigan, introduced a bunch as well. Nothing could ever get passed. So they attached this one to the NDA, and it got passed, but only after a great deal of horse trading was done to get to the final version.
Sure. The sort of horse trading we see every year before all these pet projects get attached to the defense authorization. So obviously there must have been compromises. How did those compromises come out in the statute?
Yeah, when you look at the congressional record, it was sort of led by the Democrats. And then the CTA and AML Act were the Republicans added on. But the House Republicans really pushed for a highly secure database. And that's a technical term. That is the highest security available for federal agencies. Only about 9% of all federal databases are this highly secure level. Those House Republicans also wanted to restrict when, how, and even why government agencies could access and use the information, because there is a lot of, publicly, sensitive information that's collected. And then, lobbyists and others impacted some of the decisions, particularly on which types of companies would be exempt from providing their beneficial ownership information. Which I guess I should answer your question, shouldn't I? What would I have changed in the statute itself if I was a member of Congress? There's a lot of things, but I'll focus on 3 if I can. The first was Congress was focused on shell companies. LLCs or corporations created and used by bad actors as a shell to exploit the financial system. So they decided to exempt privately owned companies that had 3 attributes: 20 or more full-time employees, $5 million or more in revenue in the previous year, and an operating presence in the United States. So these can't be shell companies, right? Now, I've called these tall, dark, and handsome companies, and I've written about these. They have to have all 3 attributes to be exempt. But the problem with these, Jonathan, and there's about 250,000 of them in the US, so there's not that many, is that they are perfect front companies for laundering money. They shouldn't be exempt.
Sure. You think about Breaking Bad and the car wash that he had, more than 5 million in revenue, probably more than 20 employees, and yet an ideal candidate to use for money laundering.
Right. And it brings in a level of complexity that just isn't needed at this stage. When you're rolling out such a big statute, and 35 million American businesses are going to be impacted by this, it's probably best to keep it simple out of the gate and add complexity as you move on, rather than start off with something that's so complex. Because you can have a business that, 1 year might have 22 full-time employees and $5.5 million in revenue. The next year, it's got 18 employees and $4 million in revenue. well, what are you now exempt to? So it just adds a level of complexity that you don't need. The other thing that I would have changed if I was running the circus, so to speak, is Congress exempted money service businesses, MSBs. Those are check cashers, money transmitters, and virtual currency exchanges.
Mhm.
So they do not have to register their beneficial ownership. Now, the reasoning behind that was that MSBs already have to register with FinCEN.
That's right.
So why make them register twice? Well, the problem with that, there's actually two problems with that. The MSB registration doesn't disclose beneficial ownership. And then even if it did, law enforcement and financial institutions don't have access to that information like they will have access to the beneficial ownership database.
FinCEN has the information, but not other law enforcement.
Correct. And on the registration form, the Form 107, as it's called, the MSB has to disclose a name of a person. That's all. So it doesn't have to disclose up to 4 legal owners and as many people as control the entity as there are, which is what's required under the CTA. And then, I said I had sort of 3 things I changed. The third, and I've called this a fatal flaw, which is a little bit of hyperbole on my part. But here's what I mean. In doing custom due diligence, financial institutions are required to ask, who are your beneficial owners? But to truly know their customers, they should also ask, what other legal entities are these beneficial owners associated with?
So, for example, you have a consulting firm, RegTech Consulting, LLC.
Yeah.
You saying, in addition to saying, okay, Jim Richards, you're the owner of this entity, we understand that, and this entity is going to be our customer, but tell us about the other companies you're associated with because we want to get to know you. That's something the bank should be doing, you say.
Oh, absolutely. Exactly. So under the CTA, a financial institution must get the consent of a reporting company before submitting a request to FinCEN for that company's beneficial ownership information.
Mhm.
So long as the reporting company provides that consent, then the bank can answer the first question, who are the beneficial owners of RegTech Consulting? But there's nothing in the law that allows a bank to ask, hey, FinCEN, can you tell me what companies Jim Richards is a beneficial owner of? That's a flaw, in my opinion.
You think banks should be permitted to ask that question and get that data?
Yes.
Okay, so Congress passes this law at the end of December 2020, and it says, FinCEN, we want you to go out and implement this law and regulations in a year. It's been more than a year, and we're not fully implemented yet. How would you assess FinCEN's efforts to implement the CTA?
On July 18th, I testified before the National Security Subcommittee of the House Financial Services Committee in a hearing. And that hearing was titled Potential Consequences of FinCEN's Beneficial Ownership Rulemaking. And I've got written materials that are on the website.
And for our listeners, we'll go ahead and include a link at the end of this recording.
Okay, great. I concluded that FinCEN's efforts have been laudable, but their results are horrible.
Ooh, horrible. That's a pretty bad grade. What do you base that on?
Well, Congress gave, and you mentioned this, Congress gave FinCEN 1 year to promulgate what Congress assumed were the 2 rules needed to implement the Corporate Transparency Act. One rule for the reporting of and access to the beneficial ownership information, and a second rule to reconcile that existing 2016 rule with the CTA, to bring them into sync.
Right.
FinCEN decided they were going to break it out into 3 rules: a reporting rule, an access rule, and a reconciliation rule. So the CTA said you got to have the rules done within a year of the act, which makes it out to January 1st of 2022 was their timeframe. They published the final reporting rule in September of 2022, so 9 months late.
That's right.
They haven't yet published the final access rule, although they've promised it again for this September. That'll be 21 months late. And the reconciliation rule was due within 1 year of the reporting rule. And we don't even have a proposed rule for that one, let alone a final rule.
Right. So they've been late with everything. Apart from being late, what else have they fallen short
on? Well, Congress has let FinCEN know in no uncertain terms that they believe FinCEN has not adhered to congressional intent. They've gone beyond congressional intent with the final reporting rule or the proposed access rule, frankly. So, for example, Congress gave existing companies, and this is in the CTA, up to 2 years to register. And then new companies that are created after the execution or implementation had up to 1 year to register. So that was the congressional intent. FinCEN took that congressional intent and turned 2 years into 1 year, and that up to 1 year into 30 days. Congress was not pleased.
with the acceleration of those deadlines after the fact that FinCEN had been so late.
Yeah.
And now tell us also about the controversy involving the beneficial ownership form itself, because we still don't have a final version of that form. And it looks like there's been a lot of controversy over that as well.
Absolutely. So the CTA requires reporting companies to report their beneficial ownership information. It is not a best efforts regime. It's like paying taxes. You don't have a choice. But FinCEN proposed a reporting form that gave companies the option of essentially replying, I don't know, or I don't have that information. So Congress and the AML community went apoplectic, basically. One commenter who I know very well had spent years as a congressional staffer and attorney, called it the worst form they had seen in 40 years of public service. But to FinCEN's credit, they knew it was so bad that within a few days, actually, of proposing the form, FinCEN came out and said, okay, yeah, we get it. We're going to reconsider and we'll get back to you. But that was in January.
Yes.
We haven't heard anything
Nope.
since then.
Nope. And it's quite a head scratcher. You'd think if they're a year and a half late, and here they give you a form and it's clearly deficient, and all the world of interested parties jump up with one voice and yell, this is clearly deficient. And Janet Yellen, a matter of days later, said, yeah, we're going to fix that. Well, what were you thinking when you proposed it in the first place?
I know it's stunning. Now, I get it, because you can imagine a situation where you're running a small family grocery store and Uncle Ted, cranky old Uncle Ted, happens to be a shareholder in this family company, and Uncle Ted's not going to give you an image of his driver's license. So you just can't get it.
Sure.
So I understand it, but there has to be a better way than just checking off, I don't know, because the bad actors are just going to take advantage of that and run with it.
It's just too easy to cheat that way. Yeah. Now, wasn't there also some controversy relating to how financial institutions would be able to get access to the beneficial ownership database?
Yeah, absolutely. Now, this is a little technical, but there's currently 3 customer due diligence rules. Everything from what to collect when opening an account to how to perform onboarding due diligence, and then how to do ongoing due diligence. So sort of 3 separate rules for those things. FinCEN took the approach that the beneficial ownership information obtained from the registry could only be used for one of those 3 purposes, the onboarding due diligence, and not for investigations, for suspicious activity reporting, or even sanctions compliance.
Ugh.
Yeah.
It means that, I used to be an in-house general counsel with a public company. And so I think about rules in terms of procedures. And if I'm the general counsel of a bank and that's my rule, I need to segregate my employees from the ones who have access to that data for the purpose of onboarding And they can never share that data with the employees who do all the other things you talked about. And that's a really hard procedure for a bank to implement.
Oh, absolutely. And if the whole purpose, the purpose of the CTA is not to collect beneficial ownership information and put it in a database. The purpose is to take that information and use it to fight financial crime and protect the financial system. So FinCEN said, okay, we're going to have this regime, but you can't use the information to fight financial crime and protect the financial system. It was a real head scratcher, and the comments that people had about that proposed access rule were uniform in that, no, you can't have this limited use for this information. To your point, Jonathan, you just can't do it operationally. And it all, flies in the face of the purpose of the act itself.
Absolutely. So if you were the director of FinCEN, how would you have done it differently? And I think I know the answer to this, but I want to hear you say it.
Well, first of all, I'm glad I'm not the director of FinCEN.
Me too.
Yeah. Just a few months after the CTA was made into law, back in, early day one of 2021, the FinCEN director resigned and an acting director was put in place. And that acting director has been acting director for 2 years. Mm-hmm. And a full-time director was just named about a month ago on July 13th. It's Andrea Gacki.
Yes.
And she's the head of OFAC, or former head of OFAC now. And by all accounts, I think, she's going to be a good choice.
So not long ago, you wrote a blog post called "If I Ran the Circus: 4 Ideas on Improving the U.S. AML Regime." It sounds like you've got some other ideas on things that you would do differently. Why don't you share those with our listeners as well?
Yeah, and I just, for some reason, that Dr. Sin's book, the title just came to me when I decided to write that blog. I think I'd distill it down to one thing, Joe, just really one thing that I would have done differently if I was running the circus, if I was the director of FinCEN. And this was sort of the thrust of my congressional testimony. I would communicate more. So, for example, FinCEN has promised to have the beneficial ownership database built and running on January 1st of 2024. That's less than 5 months from now. If FinCEN has communicated nothing on whether and how that database build out is going. They haven't published any substantive guidance for the 35 million or so U.S. small businesses that are going to have to report their beneficial ownership information. And Congress has even sent at least 2 letters to FinCEN asking it questions which FinCEN has failed to answer. And congressional Republicans are very frustrated with FinCEN's lack of communication. And remember, it's those Republicans in the House currently that control FinCEN's budget. So it's a bad idea to irritate the people that, give you the money that you need to run your shop. So if I was running FinCEN, I'd be more transparent on how FinCEN is implementing the Corporate Transparency Act.
Sure. So that's what you would do if you were the director. Andrea Gacki now is the director. As a matter of fact, what do you think she will do over the next few months?
Well, she's been there a month, right? So she's probably trying to get up to speed on everything. But with a go live date less than 5 months out, she doesn't have a lot of time. But there's clues as to what she's up to. On August 14th, FinCEN submitted a proposed rule to, it's called the OIRA of the OMB. Don't you love the acronyms in the federal the Office of Management and Budget. So without getting into the gory legal details, if a agency wants to publish a rule that has significant impact, the OMB has to review and approve that rule. So you have to submit your rules to the OMB for review. And they submitted something, and all it said was beneficial ownership information, reporting deadline extension for reporting companies created or registered in 2024. That was it. So no details have been published. And back to the communication issue, FinCEN didn't release a statement saying, oh, this is what we did. This is what it means. This is why we did it. Nothing. There's nothing. But a lot of people are guessing, and I think you've talked about this as well, that FinCEN will probably push that 30-day reporting period for new companies, push that out. What do you think? 60 days, 90 days? I'm not sure. But going back to my congressional testimony, I urged FinCEN then to push the effective date or go live date out a year, at least. Because if you think of it sort of logically, the normal progression for anything like this, a big regulatory change that needs a big database build out, you have the law, then you publish rules, then you push out guidance so everybody kind of understands what they need to do. Then you test this database, limited test, and then you implement. FinCEN seems to be doing the opposite in many respects. They want to go live, they want to implement before there's guidance and before there's even rules. That's not a good sign.
No, it isn't. So I was thinking to myself, there are villains in some movies that leave more clues at the scene of the crime than FinCEN has given us about this upcoming extension. So it looks like they're contemplating some kind of extension for entities formed after January 1, perhaps no extension for entities formed before January 1. Maybe that would be the subject of some other extension. We just don't know. But given all this uncertainty, what should we be telling our clients? What should we be telling other attorneys about what they should be doing, given where we're at?
Well, I'm not worried about attorneys, Jonathan. You guys can look after yourselves. But seriously, though, I think attorneys representing small businesses should be working very, very proactively with their clients to educate them on what is coming down the pike and how to prepare. So in my view, I think the two hardest things for many small businesses will be, the first is figuring out all the people that control the business. It's one thing to say, okay, yeah, we've got 4 shareholders, 3 shareholders, who owns more than 25%. That's written down on paper. But FinCEN decided to go beyond the existing 2016 rule, which says, give us one person who controls the business. Just name one person. But FinCEN went beyond that and said, there can be a bunch of people controlling a business. So you've got to, give us everybody who controls a business. I've been very critical of that, actually, even in my congressional testimony. I sort of joked that, in the hearing itself, I said, no law enforcement agency on the planet bursts into a room and says, how many people are in charge here, right? They'll burst into the room and say, who's in charge here?
Who's the boss?
They don't want to, who's the boss? Who's the boss? But FinCEN has decided there can be, 15, 20 bosses, for God's sake. So
that was everyone who has substantial influence.
Yeah, exactly. And so that's just, I think, a lot of lawyers will make a lot of money off that one, because that is a complicated, very fact-specific, subjective determination that can change over time. So that's where I think the bar associations really need to work well with their members, who can then reach out to the small business community. But the second piece, I think, is going to be difficult is convincing everybody to provide an image of either their passport or driver's license. So the law doesn't require that, but FinCEN has taken the position in their rule that you have to not only provide the information, including the identifying number from a driver's license or passport, but an image of the driver's license or passport, and upload that. Ironically, a couple of days, it might have been a week or so before that congressional hearing that I was at, the IRS published a notice online warning against scams, including the scam of compelling someone to upload their driver's license. And so I think that's going to be a real tough one for a lot of businesses to manage. And so I would recommend that lawyers pay close attention to that.
Sure. Wow. So we have a lot going on. We don't know where all the chips are going to fall. Thinking a little farther out into the future, where do you think we're going to end up in the world of corporate transparency and anti-money laundering a little farther out into the future?
Well, this will be a long process. And sort of without quoting Winston Churchill, it's not the beginning, it's not the whatever. Yeah, beginning of the end of the beginning. My guess is that, this is a long process. So I think the effective date is likely to get pushed out at least 6 months, if not a year or more. And I say 6 months because they're not going to have the rules done. They just can't get the rules done until roughly mid-2024. So it just doesn't make sense to have an effective date, be populating this database, and it cannot be used without the rules. So that's probably going to happen. And then some parts of the law will get tweaked and changed. The rules will get changed and guidance will evolve over time. But this isn't going away. Small businesses are going to have to provide their beneficial ownership information in one form or another. That information will likely go into a national database that hopefully is highly secure. That information hopefully will be protected. But I think businesses are going to have to provide that information and update that information. And that's something we haven't talked about, is updating the information when there's any change to beneficial ownership information. So lots going on.
A lot going on. Well, Jim, thank you so much for your time today. I know our listeners have enjoyed it, and we'll have to have you come back some other time after some more developments take place to give us an update.
Love to do it. Thanks for having me.
Thank you.